Great, thank you. And a warm welcome to everybody to this webinar on Russia and the future of the Council of Europe. My name is Alice Donald from Middlesex University. I'll be chairing the event. And it's good to see so many participants, I think, reflecting, I'm sure, everybody's deep concern about the harrowing, unconscionable events during Russia's aggression in Ukraine, and also our collective urge now to understand the implications of these developments for the future of Europe and indeed for the world order. So our focus today, of course, is on the expulsion of Russia from the Council of Europe on the 16th of March, a seismic event, absolutely, for Russia and the Council of Europe itself, one that I think holds both danger and also opportunity, perhaps. So in the next hour or so, we want to look both backwards to take stock of Russia's 26-year membership of the Council of Europe, the impact that it's had, and of course also forwards to look at the implications of a Council of Europe that is temporarily, we hope, only without Russia. And to do so, I'm joined by four speakers who I must say brilliantly qualified to help us navigate both the immediate and the longer term picture. They are Galina Arapova, who's director and senior media lawyer of the NGO, the Mass Media Defense Center in Russia. My colleague Philip Leach, professor of human rights law at the School of Law at Middlesex University, and of course former director also of the European Human Rights Advocacy Center. Angelika Nußberger, who's professor at Cologne University, a member of the Venice Commission, and who was also the judge elected in respect of Germany at the European Court of Human Rights from 2011 to 19. And Pavlo Pushkar, a Ukrainian lawyer and head of division of the Department for the Execution of Judgments of the European Court of Human Rights. That is the secretariat body within the Committee of Ministers that monitors the implementation of the court's judgments. So just a very quick word about the format of the event. I'm going to start by posing a question to each of our speakers, and then we'll open straight up to questions from our participants. I wonder if you could please use the Q&A function rather than the chat. The chat is open, but it would be helpful to have all the questions gathered together in the Q&A function. And I'm going to do my very best to get through as many as possible, and I can see that the questions are already coming in. The webinar is being recorded, and we'll share the link to the recording as soon as possible after the event. And I also just want to thank Christiana Rose very much for her fantastic organisation of the webinar. So let me begin then, if I may, by posing a question to Phil. Events, of course, have moved very, very quickly in the past month. So Phil, could you just bring us up to date with what's happened at the Council of Europe vis-a-vis Russia since that moment when the rights of representation were suspended on the 25th of February?
Yes, certainly, Alice. As you say, the Committee of Ministers on the 25th of Feb suspended the rights of Russia within the Committee of Ministers and the Parliamentary Assembly, and that was under Article 8 of the Statute of the Council of Europe, which is the provision that can lead to expulsion, as we've seen. Shortly after that, Ukraine then lodged an interstate application on the 28th, and the European Court responded pretty quickly on the 1st of March by issuing interim measures. And then on the 10th of March, the Committee of Ministers, the Ministers' deputies, consulted the Parliamentary Assembly about any further steps that could or should be taken under Article 8 of the statute. And that was followed by a PACE extraordinary plenary session on the 14th and 15th of March, when the Parliamentary Assembly found that the Russian invasion of Ukraine was a serious breach of Article 3 of the statute. Article 3, of course, refers to the principles of the rule of law and the compliance with human rights. And PACE also said that the invasion was contrary to Russia's commitments that it had taken on when it acceded to the Council of Europe in the 90s. And the Parliamentary Assembly's opinion was that the Committee of Ministers should request Russia to immediately withdraw from the Council of Europe. And if they didn't do so, the Committee of Ministers should decide the immediate possible date when Russia would cease to be a member. That was followed on the same day, on the 15th of March, by a letter from the Russian Foreign Minister Sergei Lavrov to the Council of Europe Secretary General, informing her of Russia's withdrawal from the Council of Europe and their intention to denounce the European Convention on Human Rights under Article 58. And the following day, on the 16th of March, the committee, as you've said already, the committee of ministers passed a resolution confirming that Russia had ceased to be a member of the Council of Europe on that day, on the 16th of March. And the last thing that I was going to mention, just briefly by way of introduction to set the scene, is the decision of the resolution of the plenary court on the 22nd of March, in which the court declared that it would still be competent to deal with complaints about Russia relating to violations which occur right up to the 16th of September this year. So that's 6 months after Russia's left the Council of Europe. So Russia will be subject to the court up to that date. It will of course mean that complaints can be lodged up to that point, or even later, taking account of the exhaustion of domestic remedies. So I'll leave it there, as I hope that sets the scene sufficiently for the moment.
Indeed it does. Thank you very much, Phil. Things moving at a great pace by Council of Europe standards. Now, I was going to go next to Galina, but I think that Galina is still transiting from a taxi. Ah, you're there.
No problem. I'm here.
You're there. Brilliant. Thank you. So if I may, I'd like to ask you how the news of Russia's expulsion was received, if you like, well, by you, by the human rights community, human rights defenders in Russia, and what you see, at least, as some of the immediate implications for human rights defenders and more broadly the Russian people of Russia's expulsion.
It would be quite difficult for me to talk on behalf of the all Russian audience, Russian citizens, because people in Russia have, as you might understand, quite different opinions. Some of them consider and base their assessment on what they hear from federal TV, but I definitely can talk on behalf of human rights community and lawyers who are taking cases to the European Court. And we, of course, discussed the implications and the risks and how we can proceed with defense of human rights in the country, and how we can provide, and to what extent we can provide in under current circumstances, our assistance to those whose rights are violated and have been violated and will be violated by Russia in the future. And among lawyers, we do understand and share position of the Council of Europe that within the current political situation and considering invasion of Russia into Ukraine and this horrible crisis and war which is going on, we of course understand that in that shape Russia cannot be a member of Council of Europe. But being lawyers who are working on human rights issues, we of course regret that we have lost the last hope and the effective instrument to defend human rights of those who are risking their rights, interest, sometimes life in Russia, or because of actions of Russian Federation. So we're glad that we have a little bit of time till September, plus time that we still will be able to apply to the European Court to take all those cases which are occurring now. And it's probably the only fair under current circumstances. But we also hope that in some reasonable future, when all lessons will be learned and all mistakes will be taken into account, and Russia will become a good candidate to come back to the Council of Europe and guarantee to Russian citizens and citizens of other countries respect and of human rights guaranteed by the European Convention. But that's probably a matter of some years. Who knows how many? We do hope that things will change rapidly, but in this political historical moment, we do understand that we are having quite a difficult situation from human rights defense as well. But we will do our best, and we will represent those whose rights were violated before the international mechanism, using international mechanisms. Now, European Court of Human Rights, on a later stage, probably UN mechanisms, even though we do understand that it's not, this mechanism is not that effective as the European Court. But what else can we do? Thank you.
Great. Thank you very much, Lena. I'm sure we all wish you great solidarity in that important work ahead. Pavlo, if I could turn to you now from your vantage point in the Committee of Ministers and the body that is responsible for monitoring the implementation of judgments. There are still almost 2,000 pending cases not yet implemented by Russia. Where do you see that going from here in terms of the execution of those judgments?
Yeah, thank you very much, Alice, and thank you very much for the invitation to take part in the event. Now, I have to say that some of the opinions expressed here will be my personal opinions rather than opinions of the Department for the Execution of Judgments and the Secretariat of the Committee of Ministers. But already now, for instance, I'm obliged to act in accordance with the institutional communication rules, which from 18 March 2022 refer to 46 member states of the Council of Europe and also 700 million Europeans, as well as the changes with regard to visual identity of the organization and, of course, the number of members in the Parliamentary Assembly and participation in the Committee of Ministers as well. But I will start with facts and plain facts as regards the execution of judgments. At this point, as on 15th March 2022, total number of cases that were transmitted for supervision since the entry into force of the convention was about 3,350 cases, among them 304 leading cases relating largely to complex legal problems in the domestic system of the Russian Federation. Now, as from the moment that the convention entered into force with respect to Russia, and also from the moment the execution process commenced, the total number of cases closed by final resolutions by the Committee of Ministers was 1,300, a little bit more, and among them 84 leading cases, again, cases relating to complex problems. As on 15 March, once again, we have 1,984 cases pending, among them 220 cases relating to complex problems, i.e. problems relating to systemic and structural issues within the domestic system of Russia. As regards the just satisfaction, I think it's the most popular topic also for the students of the human rights law. I would say that the number of the total debt under the judgments concerning Russia is about 2 billion euros, including UCOS. And the total amount paid for the cases closed with the just satisfaction amounts is about, with the cases closed, is about 19 million. And we have received since the entry into force of the convention information as to full payment as regards 71, the total amount of debt amounting to 71 million euros. So that's factual information that we have on this date, and I think it's important to underline it. Now, some elements relating also to the events that have passed. Firstly, on 15th March 2022, as Philip already said, the PACE decided in its opinion on the basis of request of the CM, Committee of Ministers, in the procedure launched under Article 8 of the Statute of the Council of Europe that Russian Federation can no longer remain a member state of the Council of Europe as it committed grave violations of the Council of Europe Statute incompatible with the status of a Council of Europe member state, does not bear its undertakings before the Council of Europe, and does not comply with the commitments therein. In the resolution that, or decision that the Committee of Ministers adopted on the 23rd March 2022 in its decision point number 7, the Committee of Ministers stated that the Russian Federation will cease to be a high contracting party to the European Convention on Human Rights on 16 September 22. And in line with the resolution of the European Court of Human Rights, its plenary, the court would remain competent to deal with applications directed against the Russian Federation in relation to acts and omissions capable of constituting a violation of the convention, provided that they occurred until 16 September 2022. So we have an exact cutoff date. As regards execution, this decision actually stated that the Committee of Ministers will continue to supervise the execution of judgments and friendly settlements concerned, and the Russian Federation is required to implement them. Now, what does it mean in practical terms? That's the main question. I think the first point is quite clear. It appears that ongoing obligations of the Russian Federation under Article 46 of the Convention as regards execution of judgments that were already adopted, the judgments already adopted, and that would be adopted by the court within the limits of jurisdictional competence of the court, would not be affected. In addition, as mentioned above, the Russian Federation, actually it ensues from the decision of the Committee of Ministers, would be allowed to participate in the meetings of the Committee of Ministers with a view to providing and receiving information concerning the judgments against it, or where it is the applicant having no right to participate in the adoption of the decisions and having no right to vote. And that's also a part of the decision of the Committee of Ministers. I think that for now, the legal basis for execution is rather clear. Undoubtedly, legal obligation to comply with the judgments, including the unconditional obligation to pay just satisfaction, remains unaffected. However, there are still two questions that stem from the current situation today, which for me personally are in a way open-ended. And I think the first one is the question that is the key to this discussion, is what kind of lesson have we learned from the Council of Europe, for the Council of Europe generally, but also more specifically as regards the convention system. If we assume that the convention system and the Council of Europe were built to prevent growth of non-democratic regimes that are rather likely to engage in aggressive behavior, based on indicators developed notably through the case law of the court and through the execution process, then how can we strengthen actually the Council of Europe's capacity to ensure compliance with the obligations before the Council of Europe and the convention itself? And how can we deal with the difficulties related, for instance, to pockets of resistance to execution, which include clear lack of political will to comply? And that's, I think, the key question in this discussion. Secondly, I think the second question is a question of practical nature. And that kind of question relates actually to what kind of process and what kind of dialogue could be maintained or ensured with a view to continuing with supervision over compliance with the judgments of the court by the Russian Federation after its cessation of membership at the Council of Europe and the end of operation of the convention as regards the Russian Federation on 16 September 2022. These are questions that I think should be dealt with in urgency. However, I still think that they cannot be answered immediately. They might be taken step by step, and in view of the limited time, I would probably try to focus on the execution process itself. And to say the least, the execution process is supposed to be a dynamic process. It focuses not only on just satisfaction payments, but also on the measures related to restitutio in integrum, cessation of the continuing breaches, and non-repetition of breaches that have already occurred. What we are witnessing now is rapid deterioration and degradation of the situations as regards human rights in the Russian Federation. It is quite clear that the factual situation and legal situation depicted by the judgments of the court could rapidly deteriorate even further in a number of various directions. The question would thus remain how, for instance, the execution process would be fed in with relevant factual and legal data to make it legally meaningful and relevant still. I consider it important with a view to future, as we have discussed, of the Russian Federation and its relations with the Council of Europe. It is quite important not only to have updates on the pending cases, but also as regards those cases that would be examined by the court within the limits of its jurisdiction. Obviously, the interstate cases pending execution and cases concerning the so-called complex or systemic or structural problems should be given a special consideration and thought. In this respect, I think input of civil society, various forms of permissible amicus curiae briefs or Rule 9 submissions could be foreseen. And one could also draw inspiration from reports of various international monitoring bodies, which could be of relevance to specific topics, as well as publicly available information from open sources. These are just some thoughts for now, and obviously I'm looking forward to our discussion and would be happy to reply to the questions already raised.
Pablo, thank you so much. And finally, then a question for Angelika before we start to address the questions already coming in from our participants. A broader question, if I may, for you, Angelika, looking back mainly, how do you assess the overall kind of balance sheet of Russia's membership of the Council of Europe, those 26 years? What were the broadly speaking, the benefits to Russia, to the Council of Europe itself, and the downsides? It's a huge question to put to you for a 3 to 4 minute answer, but I'd be very grateful for your reflections on that.
Yeah, thank you very much for this broad question. I think to characterize the benefits and the downsides, we have to ask the question, what is the mechanism meant for? And there, allow me just a short quotation of Pierre-Henri Taïdien, one of the drafters of the convention, because I think it's essential to assess what has happened. He said in the 40s, democracies do not become Nazi countries in one day. Evil progresses cunningly, with a minority operating, as it were, to remove the levers of control. One by one, freedoms are suppressed in one sphere after another. Public opinion and the entire national conscience are asphyxiated. It is necessary to intervene before it is too late. A conscience must exist somewhere which will sound the alarm to the minds of a nation menaced by this progressive corruption, to warn them of the peril and to show them that they are progressing down along a road which leads far. I think that describes exactly what has happened and what has not happened. We had the progress along the road that led far. So we had a development to an authoritarian regime, and probably now we can call it a dictatorship. And what has not happened, the alarm bells have not been ringing loud enough to stop before, and as it said in this quotation, to intervene before it's too late. So the process, this degradation, process of degradation just continued. And that's where we are now. We have aggression inside and we have aggression outside. And that's what the vision of the convention, to stop this process. In this sense, we have to admit that the mechanism has not functioned as it was set up. In my view, still, there were good years in the beginning. There were benefits in the beginning. And I personally would see the turnaround perhaps in 2010, but we can discuss about that. But I think the benefits, just to be very, very broad now, the main benefit was the understanding that what the authorities do is no longer done in a black hole. They might have to justify whatever they do in Chechnya or whatever they do in freedom of expression cases before the court. They might have to justify it in a legal process in Strasbourg. And that was the whole real intense shift. In my view, that's much more important than the detailed changes in Russian law. After 20 years of the convention in Russia, we had published 20 changes of Russian law, just a journal, a summary of 20 intense or important changes in Russian law about the improvement of prison conditions, length of procedure, the distinction between opinion and fact and freedom of expression case, etc. 20 such things. But first, I'm afraid these are not sustainable changes. So I'm afraid that the clock is already turned back. And second, I think that was not so important. What much more important was this necessity to explain for the authorities what they have been doing, and often to see that they couldn't give an answer. And the turnaround point for me is 2010, but as I say, it's debatable. It was the first Markin judgment, and that was the first time that the president of the Russian Constitutional Court said, stop, we are not going to follow these judgments anymore. And that was the moment when they started to elaborate a mechanism how not to implement the judgments, and in the end to filter and to take what they want and what they do not want. And in the end, in 2020, it was embodied in the Constitution. So this clear acceptance of an international order had stopped to be generally accepted, in my view, in 2010. So there were just a good decade where there was some hope for a real change. But then I think the alarm bells were ringing, but nobody reacted in the way that everybody should have reacted to it. Thank you.
Angelika, thank you very much. And actually, your last point there, I think, segues very nicely to the first question we have posed, which is from Niels Muznieks, now of Amnesty International, of course, former Commissioner for Human Rights for the Council of Europe. Thank you, Niels, for your question, which is, what red lines did Russia cross earlier without an appropriate reaction from the various Council of Europe bodies? What mistakes did the Council of Europe make that might inform action towards other serial backsliders? There's another few questions along similar lines, including one, for example, from Felicitas Benziger. Does the cessation of Russian membership set a precedent now for how the Council of Europe will deal with such acts of aggression perpetrated by member states in the future? So I guess behind this is the idea that it might embolden the Council of Europe to use sanctions up to and including expulsion that had hitherto seemed to be unthinkable almost. On the other hand, will it create a pressure, in fact, to, as I think Esra Demir has said in a recent blog, to keep the family together now and avoid it happening again? Angelika, do you want to pick up, since that was where you left off in a way, with reflections on whether the Council of Europe could have handled things better, and then I'll open it up to the rest of the panel. You're muted, Angelika. Sorry.
I might just raise 2 points in this context. One is the mechanism I have already mentioned that was set up by law, that was already implemented. So Russia already said that they are not going to implement the judgment on prisoners' voting rights, and there was no real reaction. There was no Article 46 procedure. There was no reaction whatsoever. And whenever you don't get a reaction, you just think you can go on, and you can go on your own path, and you don't have to take into account the consequences of your own actions. So this was, in my view, a mistake. It was the idea of better having Russia in and not making them too angry, and I think that was not the right thing. And the other thing where I'm very critical is the non-reaction to the agents law, because this way of declaring NGOs and all those engaged in civil society to be agents, that started, I think the first law was adopted in 2012, if I'm not wrong, or even before 2011, and there were early on cases, and that was such a systemic problem of a fight against civil society, and these cases were pending and pending and pending. They were communicated in 2017, so already quite a few years after they had been enacted, and I have checked a few days ago, I think there is still no judgment. That is 10 years. And the court had the possibility to declare cases to be a priority if they are systemic. And for me, the Venice Commission has always said that's really the worst that's happening. And each time they modified it, it was still worse. And the non-reaction to this very basic problem created, in my view, something that should not be repeated.
Thank you, Angelika. Would any of the other panel members like to respond to this broad question? What did the Council of Europe do wrong? Pavlo and then Phil.
Yeah, I think one of the issues that we have, I think it's a more like from a point of view of a general theoretical approach. The court is not the only body in the system that should have reacted probably to a number of elements that were ongoing. And probably we still have to think as to how we can standard other parts of the functioning of the Council of Europe as the body that is involved in standard setting, monitoring, and cooperation with the states concerned. And I think actually in the past years, and that's my personal opinion, the standard setting has been actually quite undermined with critical reduction of resources allocated to that. In a sense, standard setting within the Council of Europe and soft law standards have suffered tremendously. And that's something that we need to rethink as to how we can review the allocation of resources for these tasks, because I think in the economic crises, in the pandemics we have survived through, these elements really suffered.
Thank you, Pavlo. And Phil, you wanted to come in.
Thank you, Alice. Yes, I've always been a little conflicted about this point, because, as you know, at ERAT with Memorial, we've for nearly 20 years represented applicants before the court, and in a more recent post for Strasbourg Observers, I quoted Karina Moskalenko saying that the expulsion of Russia isn't a punishment of the government, it's a punishment of the Russian people, which I have a great deal of sympathy for. Not to say I'm against it, but I have been conflicted. I have been, certainly in the past, in general, in favor of keeping states within the system so that you can engage them better, so that you can achieve some measure of justice. As Rick Lawson said in his blog recently, you know, it is quite extraordinary that Russia, one of the superpowers, has been subject to this system for 25 years, whereas no other superpower has allowed that to happen. As to red lines, well, I mean, you could go back to Transnistria, South Ossetia in 2008, obviously to Crimea and Eastern Ukraine in 2014. And I would even go back further. I would go back to Chechnya, and, you know, again, 20 years of hundreds now of judgments against Russia, finding very serious violations committed by the Russian security forces and the military in Chechnya and the North Caucasus, which have remained pending. And I'd come back to the point that the question that Pavlo raised about what lessons do we learn. And I think the most important lesson is to take these systems seriously. And I also said in my post that I don't think states have done that in our experience in relation to Chechnya. We've just really seen complacent indifference from states. That's how I would summarize 20 years of trying to get those decisions implemented in the Committee of Ministers. So we need to change that. We need to take these rules, but the rules-based international order that we have, the systems that we have, take them far more seriously, engage with them, use the tools that we have in order to try to certainly implement judgments of the court, try to stop this kind of appalling development from occurring by really using the tools and the pressure that we have. Thanks.
Thank you, Phil. Galina, I don't know if you want to come in on this point.
Yes, thank you. So what the red lines have been crossed, and which we didn't notice, from my perspective, there are quite a number of mistakes that have been done from both sides, from actually not both, all of the sides, because not just Russian government as the authority and contracted party to the convention, Russian civil society, and the other side, Council of Europe and its mechanisms. Since we all witnessed that length of procedure was too long. It was quite ineffective to communicate via regular post, and even now, what we see that Russian post now is actually not accepting on a regular basis correspondence to France. So that means that now, under this crisis, new applications would be quite problematic to deliver to the European Court. And at the same time, we still have no opportunity to use e-coms for urgent communication, like to submit actually applications. That also a little bit of reflection to what Pavlo was saying as the technological obstacles that still create some problems and which created a system which was not that effective. Many cases from different raising different violations of human rights are pending and still pending for years. For instance, I've been working on the freedom of expression cases for a quarter of the century, basically, for 25 years. And we see that those cases have never been prioritized by the European Court. And we still have cases pending, which I submitted to the court over 10, 15 years ago. That means that all those questions that were raised were not reflected by the court, and systemic crisis within the country was also fed by this silence from the side of the European Court, as we couldn't get adequate legal assessment of violations of human rights in the field of media freedoms and freedom of expression from the side of the international court. And that also, unfortunately, added some problems on a stage of implementation within the country. And of course, civil society was having problems with trying to support human rights within the country, as we couldn't use to the full powers available mechanisms until it became too late. And now we see that it's not just systemic problems that we try to address to the European Court. It's also technological problems and communication problems that we face, which probably will get a lot of resources and take a lot of resources from our side, and will slow down the process of communication between the Russian civil society, which still tries hard to represent our clients, people who are suffering from violations, before the European Court. And unfortunately, well, the last point, what I would like to underline is that we noticed for many years that Russian authorities used different rhetorics and different approach in the country and on international level. They had a totally different dialogue with its own society, with people of Russia, and with the European institutions, including PACE, Council of Europe, European Court of Human Rights. Russia always allocated money in the budget to pay compensations and to meet all the requirements of the European Court decisions when it comes to the financial compensations. But at the same time, not that much of attention were paid to implementing on other level, on general measures. And unfortunately, European institutions and Committee of Ministers didn't use all their powers to put pressure on Russia. So that slowed down the process and added some value, like negative value, to the voice of propaganda and authorities when they communicated to Russian public that all these European mechanisms, they're not effective, don't use them, that pointless, and all of that. So basically, this contradiction between two different rhetorics and two different approaches, this problem was not addressed properly by probably all actors of this communication, of this relationship, including Russian civil society and the Council of Europe. So Russian authorities used it quite effectively, unfortunately. And the result we see now as the fact that Russia is no longer a party of the Council of Europe, and Russian civil society is actually the one who will be a victim of all that. Thank you.
Thank you, Galina. So I have a few questions now, which I'm going to try and bundle together because they all relate, I suppose, to the next few months, what we might see as a transitional period almost. So Martin Breuer asks, should the court continue to deal with all Russian cases now that those have been unfrozen? Wouldn't it be preferable to concentrate on a few cases, given the little prospect of judgments being implemented and the fact that, of course, Russian cases account for 25% of all pending cases before the court? By contrast, he adds, would the court be entitled to stop considering applications given the right under Article 34 of the Convention? I think it's a related question, so I'll add it here from Fred Cowell, who makes the point that the experience of the Inter-American Court in respect of their equivalent provisions saving competence after notification of withdrawal has not been good. And he mentions the case of Constantine and Benjamin versus Trinidad and Tobago as the core example. So his question is, what could the Council of Europe do to help bolster the authority of the court in relation to their summary finding on Article 58, which of course still allows cases to be brought until September? And then one also from Ed Bates, which I will just add on the end here. As we've heard, it's been resolved that the court will consider cases up to the 16th of September. Can one envisage a scenario in which Russia tries to contest this, arguing that the withdrawal from the convention is with immediate effect? So I hope that hasn't overloaded you. There are a bundle of questions which all sort of relate to this coming months. Who would like to start with those, or any one of those? Angelika, please.
Well, there is one element in the letter of Lavrov that worries me a lot, because Lavrov made a lot of accusations when he said that they now withdraw, and then he said that's why we withdraw on our own conditions. So that means, at least you can read it like that. Now we are not interested anymore in what the treaty said, and we withdraw on our own conditions. So I wonder what that will mean in practice, but in some way I understand that they reserve to react now as they want, and I'm afraid they are not interested in an effective processing of cases now anymore, and that these words have to be read in the way that they do now with those cases, what they want. On the other side, for the question about what to do now with all those many cases, I think, yes, it's very important to prioritize. The court has a policy of prioritizing, and now in this time span that we have now, I think the court should have a rigorous politics of prioritizing and taking up the most urgent problems, and hoping that there will still be some cooperation both on the level of dealing with the cases and then on the level of execution. But to be honest, I'm not very optimistic that it will not, like a machine running without oil, because the other side just does not do anything. We don't know, but the picture as a whole does not seem that we can be as naive. I think that they are going to cooperate fully now.
Phil.
Yes, thanks, Alice. Yes, I can see Russia possibly trying to challenge this. I think this goes back to the lack of clarity around the application of Articles 7 and 8 of the statute. Of course, Article 8 hasn't been used before, whereas Article 7 has. I think in the end, the Committee of Ministers took the view that they had started the Article 8 process and therefore kind of reserved the right to expel Russia, notwithstanding the letter that's, at least purported to announce its withdrawal on the day before the 15th of March. So I can see that, I think there is lack of clarity in the provisions. Going on to Martin's question, I absolutely agree with Angelika about the importance of the court prioritizing cases. I think this is in general a tool that could be used far more creatively and more often. And I know it's not an easy thing to do when you've got such a weight of cases that the court has. But I mean, just one example in the Russian context would have been to have prioritized the foreign agents case, which was lodged if I'm right, 2013. We still don't have a judgment. We now have Memorial having been liquidated, and the effect it's had on the human rights defenders, I'm sure Galina will want to comment on this, has been catastrophic. And there's no real reason why that case has not been dealt with many years ago, and it would create establish a global precedent, and we need it across the globe given what's happening in a number of countries. So yes, let's use priority process much more effectively and efficiently. Thanks.
Thank you. Pavlo or Galina, do you want to come in on these questions?
Yeah, I think as regards the prioritization, I think it makes sense also to synchronize the examination of cases before the court. Of course, I'm not competent to speak about that with the ongoing execution processes. So that's just a brief comment.
Thank you. And Galina?
Yes, I also have a brief comment on prioritization. I think it makes sense to focus on interstate cases, and I agree with Konstantin, who just had a similar comment in our chat. And I think that like key issues that are raising like a very essential and existential issues, they have to be considered first, plus the ones that will affect at some historical point human rights, which are like maybe like more important, if I can say so, including issues of fundamental existence of human rights organization in the country. And in this case, I totally agree with Phil that the case of foreign agents, which is pending before the court for years, it was I think it was a mistake not to consider this case earlier, but now it's a lot more critical situation. It still has to be considered, even though majority of organizations are now just facing similar fate as memorial and could be liquidated. It still has to be, this case has to be decided as in some, maybe not nearest, but future. It has to be some legal grounds for not just lessons learned, but also implementation of these decisions in the Russian civil society in a new situation within the country. So fundamental issues like Article 3, but also Article 10, 11, 8 at some point, Article first, Protocol 1, though all those cases are quite critical to my mind with regards to addressing painful issues, which are now we see in Russia, in Russia, and how the silence of the European Court affected development of situation in Russia. So I think that maybe picking a few critical issues and prioritizing those cases and grouping those grouping cases and giving some priority and joint cases which are similar and raise similar critical issues, which also might be a basis for further diplomatic dialogue with Russia. Even if Russia at this point will resist any kind of like cooperation, I think it's still a matter to try and have this dialogue for the sake of future stabilization of situation and democratic processes, restoration of democratic processes in the country.
Thank you, Galina.
Thank you.
So we've got about 5 minutes left, but I think we did start rather late. So with everybody's indulgence, I will continue beyond 1 o'clock London time. And I want to take another bunch of questions, which again have a forward-looking dimension. First, from Andrew Ford, does the panel have any views first on the situation of convention rights holders who remain in parts of Ukraine occupied and under the effective control of the Russian Federation when the war ends? And secondly, has the Council of Europe got any capacity to support human rights defenders, media and civil society in the Russian Federation? as a hostile non-member state, as proposed by the Parliamentary Assembly to the Committee of Ministers. I think a related question from Nora Verhofsitz from the Human Rights House Foundation. She asks, what other new independent mechanisms to monitor and report on human rights violations in Russia domestically and in occupied territories can the Council of Europe implement? How can continued cooperation with Russian civil society and human rights defenders be assured after September? And just one more to add on to that from Lilian Apostol. Can the Council of Europe act preemptively to stop spreading conflict escalation in other, what she calls hot regions, such as Transnistria, Nagorno-Karabakh, Abkhazia, and South Ossetia, with Russia as a neighbouring country, but of course no longer a member of the Council of Europe? Again, that's rather a lot to throw at you, but please pick on any parts of that that you would wish to. Who would like to start with that bundle of questions? Galina, the point came up about how the Council of Europe could continue to support and relate to Russian civil society as is its stated intention. I don't know if you have any ideas about the practicalities of doing that.
To be honest, Russian human rights defenders didn't really have a chance to discuss it thoroughly, how we can continue to be engaged into dialogue with the Council of Europe. Now we're just more concerned about how to document, put together and deliver to the European Court pressing issues of violations of human rights, which are now just happening like at like every single moment, both in Russia and in Ukraine. And but I think it's actually quite an important issue to decide what else we can do, not just to deal with cases, particular individual cases now, but also to ensure that Russian civil society.
I think Galina might have frozen momentarily there. Would anybody else like to pick up?
What can we do?
Sorry, Galina, you froze for a few seconds there, but you're back now. Sorry to interrupt.
Sorry, that's incoming call, which interrupts our.
Okay,
so
sorry.
I'm sure that we have to find a way to continue with.
I think the interruption has happened again. Galina, can you hear us? Seems that Galina is frozen. Would anybody else like to pick up while Galina's connection resolves itself? Phil?
Yes, I'm just would like to pick up what Galina's point about well, your question was about civil society, and I think looking ahead, I think there's also a big challenge for the Council of Europe in relation to the proper involvement of civil society and academics in this field and practitioners and people who represent applicants. After all, this system is really for the victims of human rights violation. Not only that, but that's fundamentally what it's for. And I think there is a history of the way in which the states have debated about possible reforms, which has been exclusionary. It hasn't properly involved those wider groups, and I think that needs fundamentally to change. I think there's a huge amount of knowledge and understanding that is lost when states get together. Andrew Ford's blog suggests another heads of summit meeting, which I think can be done. But what is very, very important is that states properly engage, and I mean meaningfully engage these other voices. So that's one point I'd like to make. I mean, in relation to and I think Andrew also had a question, as I understood it, about those in Ukraine under Russia's effective control. I think this is a reference to the Georgia-Russia 2 interstate case where the court found it doesn't have jurisdiction in relation to the active phase of conflict. So we have now a very we'll have a whole series of decisions which will turn on whether there is Russian effective control in Ukraine, or whether on the other hand the violations occurred during the active phase of conflict, and what a difficult process that's likely to be. Thanks.
Thank you. And Galina, I can see that you're back now. I'm so sorry. We weren't sure how long you'd be frozen for, so we moved on. But please, if you can pick up where you left off, that would be great.
Hard to say when you've what I was saying when you've lost me, but just to sum up, Russian civil society, human rights lawyers, we do try to put together our understanding how to continue under the current circumstances, and to ensure that our clients have a proper defense of their human rights. And also we will try to put some ideas and present it to the international community and international organizations and Council of Europe and other intergovernmental bodies on how Russian civil society and human rights organizations will be able to continue to be engaged into some dialogue, and to bring our understanding of situation from the ground to the international level, and how we all can actually, if not put some effective pressure, but at least raise our voice and try to develop some mapping and understanding of what else could be done based on lessons learned, of course, and hopefully we will be effective in our new approach and in our new efforts altogether. Thank you.
Thank you, Galina. Pavlo or Angelika, did you want to come in on this bundle of questions? Angelika.
Well, the whole system basically depends on a dialogue with the state. So ratification is the first step to work together. And obviously there is no work together, but still I think it's extremely important to do whatever can be done now when you lose your dialogue partner, and you continue the dialogue with those who are behind the dialogue partner, so the civil society. So even if they have left the country, I think many have left the country, they have to be supported, and the Council of Europe has to show that it's the main issue for the Council still, even if the 47th member state is not there anymore. That doesn't mean that the problems are not there anymore. They have to remain on the agenda. And I think the most important word was what Galina said about documentation. So whatever you can document about human rights violations that are going on in the territory that might be occupied. And I agree with Phil that it's going to be very difficult to decide what's an ongoing conflict and what is already a situation where you can talk about jurisdiction. That will be a permanent question to be answered. And that's why all the details have to be collected now, at least, so that afterwards you can work on it. I think that's the only thing you can do right now, really.
Thank you, Angelika. Pavlo?
Yes, I think you might have seen that the court has issued a decision on 1st March 2022 as regards to the interim measures, which are relating to the situation. And without going into further details, I would like to encourage you to read also the press release as regards to interim measures, which are now covering all individual applications as well lodged as regards the ongoing military hostilities. And there is a reference in this decision and the press release to Georgia-Russia number 2. Also, arguably, I think from a legal point of view, still we have non-derogable rights, and probably rights that could not still, even in the case of Georgia-Russia number 2, are still engaged, notwithstanding the active phase of military hostilities. That's one comment. And then also a comment with regard to what Lilian has said. I think there is now quite a lot of discussion about the propaganda, war propaganda, and the elements related to the fact that propaganda is not covered by the protection of Article 10 of the Convention. And I think that's a very serious discussion, and that's something we can be engaged in. And I think that's something where the Council of Europe also can say something from the point of view of its soft law standards as well.
Great. Thank you, Pavlo. Time for, I think, for another round of questions. And again, I'm going to stick with the more forward-looking ones. So one from Jamie Brown at the Council of Europe. He points out that the Russian Federation has, of course, been a complicated and often disruptive presence in the organization in myriad ways. In the spirit of searching for some silver linings in the midst of what is otherwise a potentially existential crisis for the Council of Europe, does the panel have any ideas about potential strategic opportunities or positive steps the Council may take in the absence of Russia being a member? And then a couple of questions very similar from Harry Hummel and Sergei Masol. What should be the conditions for Russia's membership in the Council of Europe if it decides to return in the future? Harry Hummel adds, should a future normalization of relations, assuming that moment arrives, be conditional, for example, on acceptable participation by Russia in dealing with this backlog of cases before the court and pending before the Committee of Ministers? So two big forward-looking questions there. Anybody like to start with these ones? So positive opportunities that arise from Russia's absence from the Council of Europe. It may be a bit early to see those, but Angelika.
I don't know concrete examples, but I have heard that some reform measures, some new projects were being blocked by the Russian side, and so there seems to be some unblocking opportunity now. But I cannot give you concrete examples. But that's often like that you have a political stalemate and you respect one party and then you don't push, and there seem to be some project that might go forward now, but unfortunately I have no concrete examples. And for the conditions for a return, I think that's an extremely difficult question. Nobody has the glass bowl to look in the future what's going to happen, but I think a basic precondition would be to live up to the standards of the UN Charter and to go back to well, not to conquer the territory of another state, so to withdraw the troops and if we have some peace settlement, but then also the politics of the interior have to be in line with the standards of the Council and with democracy and rule of law. So that will be, it's important to give this possibility to say the door is always open but I think we have to admit a lot has to be changed before, but changed back before it will be possible.
Mm. I just add in one other question that's related here from Piers Gardner, who wonders if the consequential reduction in the caseload of both the court and the Committee of Ministers from Russia's departure will create any opportunities, although of course what has also been lost is Russia's contribution, and there are severe implications for staff at the Council of Europe. Angelika, you want to come back in?
Yeah, just to add, the problem is, it's true that the case law in general, the load of incoming cases will be reduced. But right now, if the court wants to work on the Russian cases with some priority now, immediately, I mean, that's a huge task before they can see that there will be less. So I see, but as I have heard, I think Germany and France have already promised to give additional funding so that the loss of the budget will not be so detrimental for the work of the Council. But this less incoming cases, that will not be as of now, but that will work out only later.
Indeed, thank you. And Phil, I think you had your hand up.
Yes, thanks, Alice. I think the greatest strategic opportunity is now to reflect very seriously and think about a reset about the whole system, to look back over the last quarter of a century. I think that's the greatest opportunity, and we need states to give full-blooded support to the system. So often we don't see that, we don't have that, and it applies to countries like Turkey. It also applies to countries like the UK. Angelika, you mentioned the prisoner voting rights in Russia, but of course that was after the issue was raised in the UK. So we need to have, I think, proper meaningful support. We need to rethink, I think, what that means, and I think this is an opportunity to do that. And finally, just as I think also with countries like Azerbaijan and Turkey, who are seriously violating the convention repeatedly, I think also we can have a rethink and a reset about how the court and the Council of Europe deal with those states. And again, coming back to the point about using all of the tools that we have at our disposal. Thanks.
Thank you, Phil. Pavlo or Galina, do you want to come in on either of these questions?
I think just very quickly, I think one of the golden opportunities now is possibly the accession of the European Union to the European Convention. That could also probably strengthen the resources that this organization has to deal with human rights. That's one comment. Another comment probably is relating to reassessment, and I fully agree with Phil on this, that this is some form of very complicated disruptive change for the organization that might lead to reassessment of how this organization functions. And actually now there are talks about the next summit of the heads of states of the Council of Europe. The last one has been organized in 2005. So now I think it's the time also to see where this organization is leading to. So that's an important moment.
Thank you, Pavlo. And Galina?
Just a very short note. I think it's not probably the time right now to discuss what would be the conditions for Russia to come back, as we are at the very beginning of the process of Russia coming out of the Council of Europe. And I think we will have for a year or so quite a lot of cases coming to the European Court from Russia, or with regards to issues of violation by Russian Federation human rights of citizens of many countries. But for the future, I think it's important to have to keep the door open, because Russia is a big player in this region, in the Eurasia region, and definitely big Europe is not interested, I believe, in having such an aggressive neighbor who would not respect human rights, and definitely that might affect situation in Europe in the future. So I think everybody, all parties, should be interested in the changing situation, and of course, for like a fundamental change, political situation in the country, political regime, respect to human rights, like meaningful respect to human rights. All that has to be changed. And I think many of us, not just the Russian civil society, which are quite often blamed that we didn't do something to ensure that a situation in the country would not come to that critical point. I think not just Russian civil society, but many actors, including big international players, who could have been, and I hope they will, be a bit more pushy, not just pragmatic from the financial and economical point of view, but also pushy with regards to all parties, including Russia, reaching and respecting and ensuring standards of human rights and a modern understanding of decent civil society globally. So I think that it's a lot to be done in the future, and I really hope that Council of Europe will not exclude Russian civil society as potential player in this big game.
I think we've lost Galina's connection, but the point was very well heard and very well made. Thank you, Galina. I think we perhaps had better leave it there. It's now 1:15 in London, and we did promise an hour-long webinar. So I'm so very sorry for the questions, those who post questions that we haven't got round to answering. It's been interesting just reading them, actually. So please forgive me for not getting to all of the questions that have been posed. But I want to thank again our 4 speakers, Angelika, Phil, Pavlo, and Galina, for their insights. And I feel sure that we will be coming back together in the coming months to discuss all of this. It's very early days yet, indeed, to process the enormity of what has happened. But it remains just to thank again our speakers. Thank you to all of our participants. Thank you again to Christiana for organising the event. And Phil, would you like to say something?
No, I was trying to clap rather than raise
okay.
my hand, and I failed. So that was me clapping, Christiana and the speakers and everyone else.
Thank you, Phil. And thanks again to all our speakers and participants. And again, apologies for not getting to every last one of the excellent questions that we had posed. Thank you.